Hey everybody, welcome to the show. My name is J.D. Houvener, and I am a patent attorney, and I'm also the owner here at Bold Patents Law Firm. I'm here every Wednesday morning at 9 o'clock on the West Coast and noon on the East Coast. I'm here to talk about everything patent law, even bring on some intellectual property stuff too. So trademarks, copyrights, trade secrets, I'd love to kind of bounce those off. But patents is the name. I mean, that is what we want to talk about here today. And the subject matter for today is file that child application. Some of you guys may have seen that cute kid we had on the photo. And that's truly, what is a child application? We're going to start there. We're going to go all the way through how to develop a patent family. Okay, maybe kind of start to learn what some of this patent parlance. Welcome all those live viewers out there. We are going to prioritize live questions, just like we did last week and all the weeks before. I do have preloaded questions from Avo. I've gotten, I think, 8 or so questions this week, so I'll be featuring those. If we don't get any live questions, and yeah, the show's going to go this week. I'm sorry, there's not going to be a $225 giveaway. That was one of our most popular sessions we had last week when I was giving away money. So hey, hopefully we get a decent showing today, but if not, next week I'll be doing another giveaway. All right, so for those that are joining in a little bit late, I'm J.D. Houvener. I'm the owner and patent attorney here at Bold Patents Law Firm. Certainly not the only attorney. We have 6 talented patent attorneys here and are working with inventors. And we do primary work with startups, first-time inventors, entrepreneurs that are looking to lock in a technology and make that a major part of their business and monetization plan. So let me get started here with a little brief disclaimer. I want to make sure you guys are aware that although I'm an attorney, this is not an attorney-client privilege discussion. I'm not your attorney, at least not yet, and I don't want you to share any confidential information. So I'll put that legal notice in here for all of us to make sure we're sticking by the rules, right? We don't start talking about invention. So keep everything hypothetical. Process questions are great. Any questions about the the system itself, I'd be happy to talk about. And help you through some of those patent questions. So bring it on. This whole session, I'll be looking for those live questions that come in. We're broadcasting across Facebook, LinkedIn, and our YouTube platform. So we could get questions from any one of those. And then the comments can be delayed about a minute or two. So if you don't see your comment pop up or you don't hear me respond to it right away, just hang in there. I'll be getting to it shortly. Okay, so let's talk about child patents. Okay, and what I'm going to do is I'm going to share my screen for about 5 minutes. I'm going to show you this little slide deck all about what it means to develop and file a child application and why it's so important to do so. And then we're going to go to our Avo questions. And from there, I'm going to be launching into a link to our website where you can learn about more about PCT and patent cooperation treaties, the foreign filings, how to build a portfolio, how to get started with the patent search and all that stuff. And also how to get a free copy of this book behind me, Bold Ideas, The Inventor's Guide to Patents. All right, so let me share my screen. All right, so we're talking about the Patent Portfolio Guide. All right, and this is, and when I say patent portfolio, we're just talking about developing from an initial parent application to filing child patent application. So what's the difference between that? Well, I mean, a parent application is the first. It's the first patent application you file and generally has the largest disclosure, right? You're telling the whole world, here's what I've invented. I've got this new solution to this world's problem, right? And here's everything about it. Here's the way it works. Here's the different versions it could have. And in almost every case, literally almost every case, there's an opportunity to file the child application, which is sort of a version of that parent. And it looks a lot like the parent, right? But actually is different, right? And it must be filed before the parent issues. That's the most important piece here, is that you have to do it. You have to file that child and develop your portfolio before the first patent issues, right? And this is something that we push and present to our clients and help them sort of think through quite a bit. So yeah, let's get to it. Let's start talking about what do they look like? Or what are the different kinds? And so there are 4 major types of child patent applications out there. A divisional application is when right up front, when you file that big parent application, the examiner is going to see if there is more than one invention, right? Their job is to make sure they have enough time to do a really good search and confirm whether your invention is patentable or not, right? That's their job. So if you have more than one invention there, that would be doubling or even tripling their work. So they're going to be like, no, I need to get credit for 3 separate applications if you're going to be sending in 3 different inventions. And this is really common when you have a device, for example. Then you have a claim for the method of using that device, and then perhaps there's sort of a system or an algorithm, process based for performing that method. All 3 of those are separately patentable, patent eligible, and they should be considered. And therefore, what will happen is you have to select just one of those to be the parent, and the other 2 sort of are on standby. And at any time before that parent gets the issue, you should really seriously consider going after and filing what's called a divisional. And that's just going after that method or that process claim and proceeding through to prosecution. Now, continuation application is a little different. This is when you have gotten far enough along and you know that there is some part of your claim set that the examiner said, no, that's not, in my opinion, the examiner's opinion, not novel or not new. And is obvious based on the prior art. And at some point you say, okay, well, we're going to modify the claims and try to get the parent issued. And finally you get to the point towards allowed, right? The examiner says, all right, we'll let you through. Well, any of those claims that you had to modify or take out in order to get the parent allowed, you can actually file a continuation application with that, going for it. Now, in other words, having a bit more of an argument, legal argument, or making further amendments and trying to capture that invention as claimed that you sort of had to deviate from during that initial prosecution of the parent. Now, the continuation in part is quite different because you're actually adding new subject matter. Okay, so you're actually adding and providing new invention subject matter, and so it'll have a new priority date, but it's still related to your parent application. And maybe it's a discovery you had in the lab, or after you had customer feedback, you found out that, oh my goodness, I totally forgot about this really, or I didn't think about this really neat modification or improvement to the application, or the invention rather, and I really want to go after this. And so instead of filing a brand new application, you actually can get some benefit in the priority date by filing continuation in part. And you get the benefit of already having it be starting through the process, and usually gets assigned to the same examiner. So there's some strategic things to think about whether you want to file a new application or continuation in part. Design patent application is also considered a child because you're moving through with a utility application. Let's say it's for an electric scooter, okay? And you've got the utility about how it actually looks and the structure and the components and how the motor is actually able to propel the scooter forward, and the attachment to how the board fits with the wheels. That's awesome. But before that utility patent for that motorized scooter gets allowed, you actually realize, oh my gosh, the way that the motor sits on the board, the way that it looks is actually unique, right? The actual appearance of that scooter is new, and you want to protect that shape of the design of how the motor integrates with the board of that scooter. That would only be protected under a design patent application. And so in that essence, you're actually going to be able to broaden out your ability to enforce your patent rights by having protection on both the utility and the design side. So those are the 4 main types of child patents you can file. Before I move on, I want to check to see if I have any live questions on kind of those subject matter. I don't see anything right now. But if you have any questions, maybe you're watching this after the fact, I would encourage you to please put those comments in. I'll be sure to get back to you, even if it's after the broadcast here. So it's a bit of a complicated chart. I just want to show you some timeline and how this works. The main parent, or otherwise known as the filing, the first filing, follows this gray line in the middle. And what's great to know is that all these different types of child patent applications can get varying priority dates, okay? And when you would want to file those, depending on how the parent application moves along. So I won't get mired down in the details here. I can definitely provide this to anyone who's interested in learning more about when and how to file these child applications. And just briefly, I did pull this up before the meeting. Here's a lovely family here, just to show you what it means to develop a family, why you might want to file that child application. You can just see this is the parent, right? One parent. You could say sort of the marital unit, okay? Both parents, if you will, in the real life scenario. This first parent application, right? after that, just before that was issued, there was a CIP, a continuation in part. You remember that terminology here, CIP. That was filed. And so this patent was born. And before this was issued, there was a CIP of the CIP over here. And there was also a continuation. Another CIP off of that. From that application, you can see there was 2 separate continuations that all point back to a PCT, which is an international application at the U.S. Patent Receiving Office. And there's indeed even a further chain. I mean, look at this, 5 separate, layers. You call it generations of patent portfolios. And if you look at these numbers, I mean, 9 million versus 10 million, that's probably around 6 to 7 years, worth of development. So, while the inventor might have just come away with just one patent, because they were wise to develop other versions, other modification improvements of their invention and capture broader rights, they have upwards of 10 plus, plus all the international applications that they likely have as well. So, and it can get even more complex. You can look at this very robust patent portfolio. Over 25 patents were issued, child patents, all born from one parent application here. And here you can see it's almost over the course of 10 years, this portfolio has been developed. So you can do it too. And so it's something that you should really consider if you're moving through the patent process. Is how to file a child patent application. Do not come away with just one patent for your invention. In almost every case, you'll be able to get broader rights and more protection by filing a family. The even more reason to do so. In every conversation I have with patent brokers, with who are actually out there selling inventions, in every conversation I have with a litigator, they love to know that there is a pending child application, right? That there is a portfolio under that initial patent that has been issued now. The benefit of having that is that you are able to go through a great negotiation and settlement with, let's say, on the litigation side, with someone who may be infringing your patent. Sure, it's scary that you have a patent that might be indeed reading on the product that they're selling, right? They may be liable for infringement. But even if they're able to change their product or argue that they're not infringing, you have that child patent application, and you've got the ability to make amendments, and you could sort of have it in your back pocket, and you could make an amendment set that you could lock in and be identical to what they're trying to sell. The other side, on the brokering and the sale side, it's kind of in the same thing. It gives you more value because there is not just one patent, but several, and you likely would be able to get a larger royalty or sale if you have a demonstration. You can, show you have the patent portfolio. Ariana Lawrence has got a question. Thanks for that. Let's bring it up here on the screen. And a beautiful family you have, by the way. Does a parent-child filing apply to provisional patents? I read somewhere that you should include any and all applications, the greatest possible universe in the original provisional. Yes. That's an awesome question. I love it. Okay, so a provisional patent application is the first. It is an informal version of the non-provisional. Okay, and it has less requirements than a full non-provisional does, but it lays the foundation. And what I like to say, it creates the palette, right? The palette of paint that you'll paint with on the canvas when you finally submit your final formal non-provisional. And so absolutely, after conducting a rigorous patent search, making sure you know exactly what's novel, what to speak about, that's when you write as broadly as you can, cover every single version, every embodiment, everything you can think about, every way your invention could work, all the applications possible. Don't hold anything back. You want that provisional to be really all-encompassing. And that's one of the mistakes that I think some inventors, if they file on their own, they make a big mistake. And they just file one version, right? They happen to manufacture or prototype something that works. They get all excited. They hear patent, to file the patent. And so they just talk about the one product that they made, when in actuality, what they've invented is this whole body of knowledge that could apply to maybe 100 different types of industry applications, but that provisional didn't talk about it. So you bet you got some good advice from somewhere that yes, indeed, you should include all sorts of things. Okay, so when that provisional gets converted into a non-provisional, that's when you have to decide, okay, what are we going to claim here? And like I said earlier, usually you'll want to claim as broadly as you have that provisional. And typically we'll say, let's file on the device, the method of using the device, and perhaps even the process for how those steps come together. And in many cases, the examiner says, well, hold on, you've actually got more than one invention here. And that's when that divisional comes into place. And you can just select which one you want to move forward with first, and then come back later and file those child divisionals later. So I hope that helps answer your question, Ariana. Thanks for that question. Okay, let's jump to our avlo.com questions, and I'll bring those up on the screen. And Ariana, if anybody else has any follow-up questions, you're welcome to fire away. I'll be here for another 10 or 15 minutes. Okay, so this first one we have, let's see here. No questions on patent application or infringement, but I've got 4 trademark application questions, so I will go to those. I'll bring those up on the screen here. You're welcome. All right, so the question is, again, this is trademarks. Whoops. Okay, can I have a DBA with the same name as a corporation minus the incorporated, the Inc. Abbreviation? I had a DBA with the same name as my contractor's license. I unfortunately let it lapse. Someone opened a corporation with the exact same name, except they added Inc. at the end. Can I renew my DBA? Okay, well, DBAs, although also known as trade names, if I'm following the question correctly, these are state specific, okay? And they are, for the most part, unrelated to trademark law. Okay, they're tangentially related, and they're fairly loosely enforceable. The most enforceable way to go for protecting your name, if you're going to be, a company that sells to customers interstate, right, outside your state, is to use the USPTO, the trademark office, to get a federal trademark registration for your specific classification. A DBA, I hope I'm following the question correctly, is related to registering your trade name with your Secretary of State, okay? And the only search that Secretary of State will do is if there's an exact name match, okay? And typically they will make you include your entity type, LLC, C Corp, maybe a not-for-profit, whatever it is, however you form, sole proprietorship as well. And that's it. They're just gonna make sure there's not an exact match. They won't look for similar sound-alikes or confusingly similar marks, which is what the federal register and the federal trademark examiners will look for. I guess long story short, depending on your classification, and it looks like you're, if you don't know what kind of industry you're in, but let's say you're in, painting houses, and someone has the same exact name, House of Color, okay? House of Color LLC is your name, and House of Color Inc. came in after you kind of let yours lapse. You didn't pay the trade name fee. Maybe you stopped using you didn't practice, you didn't paint houses for a number of years, and now you want to come back, but like you said, you found another name, House of Color Inc. has got their DBA. Well, what you really should start thinking about is confirming that House of Color Inc. is actually a painting company, okay? House of Color Inc. might actually be a physical therapy office, okay? I don't know, right? They're very interesting concept. Maybe they're doing, diversity training, House of Color, okay? And they're totally unrelated to painting your house. Under trademark law, you would likely still be able to, assuming there's no other similar or confusingly similar name, you'd still be able to register House of Color as a word mark at the federal level because there's no one else competing for painting, right? House painting services using that mark. Hope that helped answer your question there. Okay, I'll do one more trademark question. I'm hoping we get one more question out of our live community. Well, that's another DBA question. Okay, let's see. All right, this one is coming out of Nashville, Tennessee. Okay, is a trademark first to use or first to file? I do not have the money to trademark out the gate. I have a character I've created and will be selling merchandise such as clothing, coffee cups, and a brand. However, do not have the money to trademark. I need to test the market, see if it works, see if people want to buy it, basically, yeah. Is the trademark first to use or first to file? Do I have any protections? Can I negate a trademark filing if someone attempts to take my idea? Cool, I like this question. And in general, it is first to use, okay? First to use wins in trademark, as opposed to patent, which is now, as of 2013, first to file. Doesn't matter who invented it first, whoever files it first, that's who gets the right. So if you're using, your mark, let's say it's, Monkey Boy is your cartoon. I'm just making it up. Monkey Boy, and if you're the first one, if you're the first priority to use Monkey Boy, have your cartoon made and have a brand you're developing with that, obviously with a logo or a picture icon, as well as some word marks. As soon as you start, entering the stream of commerce, and especially as soon as you start selling interstate, right, outside your state, certainly outside the country, you're demonstrating that you are using that mark. And that is the date whenever you can demonstrate that you've made a sale. That is the key. When you actually sold your logo, your products with that logo in mind on the open market. That is what the trademark office will look at when you eventually, hopefully you get enough money to file registration. So you don't need to file first. You just need to go into market and using it. Know that if you do that, you are taking the risk that there's someone else using the name Monkey Boy in the same industry, same type of classification. And you might actually find out, unfortunately, that you're infringing their rights. So to be wise, you should do a search. Certainly a trademark attorney, we have one on staff here at Bold Patents, can help you do a search like that, even if you don't have enough money to make it all the way to the application phase. So thank you for that question. Looks like Ariana has a follow-up question here. I love it, by the way. Okay, so let's put these up. I'm going to take a stab at drafting a provisional patent application on my own. Don't do it. Number one, do I include all references to all previous patents in the provisional? Two, what is your recommendation on including claims? What is your recommendation on a good resource to use to draft this provisional on my own? Well, like I said, don't do it because it is something that takes a long time to practice on doing. It's like, yes, you can file your own taxes, but are you going to really get the best bang for the buck, or is it worth it to just hire a professional and get those taxes filed the right way and get all the right discounts or whatever they say, write-offs? And in almost every case, yeah, it's better to hire a professional and allow you to spend your time, right, your valuable time, not muddling through and learning a new process and writing. You actually should be spending your time inventing, right, or starting your company and investing your time and energy on something that you're passionate about. So that's my soapbox. Again, obviously you're going to do what you want. I actually have a lot of material about how to write a provisional patent application. And I've written about a blog article, lots of blog articles about this. Let me see if I can pull up one. All right, so here is one, how to file a provisional patent application in 13 steps. Again, don't do it. I'll share the link here for you, Ariana. That is our blog article that I put out. And I'll share screen really briefly to show you what that looks like. So yeah, even though I'm saying don't do it, I did write an article on how to do it. But honestly, the trick is, I've got videos on how to do it. I've got the reality check. It's complicated. And this blog article is long and lengthy, and it goes through all the nitty gritty, and it's supposed to scare the daylights out of you. Okay. It's supposed to scare you into thinking, yeah, you know what? This is a lot. And to do it right, I'm not gonna have enough time. Let me hire an attorney. Okay. So honestly, just to be real above board, that's what my efforts were. But the information is there, and it will actually help you if you want to go through and do it. So kudos to you for having the initiative to get after it. All right, guys, we're going to wrap up. I'm J.D. Houvener, and I am the owner here at Bold Patents. If you missed us live and you want to catch us, I'm here every Wednesday at 9 a.m. on the West Coast and noon at your lunch break on the East Coast. So I'll see you next week. Have a great day, everybody. Go big, go bold.